There's an opportunity if family law lawyers and judges and maybe the mental health professionals and then parents knowing for themselves, there is an opportunity to really set kids up better if we are aware of this from the get-go. So what are your thoughts about that just as a framing kind of topic?
Yeah, absolutely. There are like you just laid out, there are so many intersections. I have seen it and been involved as on a consulting basis when it even comes down to the basic, right? The best interest of the child. What is in the best interest from a custody perspective? When you have a special needs child or a child just with an IEP or a 504. Now, IEP is that's a term of art, and depending on where you are, it could be called something else. In Texas, they call them ARDs, ARD, right? All of it means the same thing. It's a specialized learning plan to meet the needs of your child based on their specific condition. So that's across the board. But that's one of the areas that I absolutely know is overlooked because when you think about it, the family law attorneys that I work with that do custody specifically, they look at everything. They look at location, they look at of course, they want to make sure that is their client. They want to make sure that is their client who gets the child. I mean, that's the whole purpose, or gets what they want. But even when you have a joint custody, a joint physical custody arrangement where you have the kiddo is with dad Monday, Tuesday, Wednesday, they're with mom the rest of the week. And even though they are going to the same school, the home environment is different. And so a lot of especially our more severe kiddos, but I think it applies to anyone. One of the things I always talk with my parents about is there has to be some consistency. There must be consistency because a lot of our kiddos, depending on their condition, those 3 days, I'll just say at dad's house, not for any reason other than we gave
Yeah.
dad shorter days.
Yeah.
But if there's a different structure at dad's house and a different structure at mom's house, it's going to affect our kiddo at school because they're going to be dysregulated. So some of the conditions really require almost an identical structure. You also have parents that are in sometimes denial of there even being a condition, the severity of the condition, they'll grow out of it, all of these things. And so they take that position. And so they don't follow some of the items that should be followed. And then now their child regresses. Part of the challenge someone like myself would see is it the school's problem or is it this dynamic between mom and dad? And the differences based on that. So that's one of the things that who is in the best position, even it being an additional factor in that best interest of the child analysis. I don't know exactly how deeply a lot of family law attorneys go into that. This is one of those areas that could really be a game changer, I believe. Just knowing that and really just understanding how that factors in, I think definitely provides a lot of leverage. And it's not just who goes to the IUP meetings.
Now, the other thing that's striking me is that I think is real important that we make sure we cover is really when you are getting divorced or going through divorce or you are divorced or you are have split up from your parent, your co-parent. I think it's I don't know what the percentage is. I'm just going to spitball it. I'd say there's probably maybe 80% chance, maybe high, that you're fighting about this topic. Okay, because when you're breaking up and you have a kid that has challenges, oftentimes you're not on the same page, right? And that can become a defining piece of why you're breaking up, right? And so I see frequently, maybe it's just the case. I mean, first of all, do you think that might be true? I don't know if you work enough in divorce to even have a sense of whether that's accurate, that it's high, that it's a source
It's
of
definitely high.
okay.
It's absolutely high. Because sometimes even the challenges with the children, depending on how severe that they are, depending on if there is a difference of perception with the parents, that could be one of the major issues and a real sticking point. If a parent really does not believe and they're just dug in, that there is not a problem, they are going to be very concerned. And so they're going to frame it as if, okay, other parent is hurting the child by saying
Yeah.
these things about them, or, characterizing, child behavior as a disability or a condition. And so essentially, there is a listing of certain conditions. Some of them are physical, some of them are mental, some of them are developmental. They also have a catch all, and I'm saying catch all, called other health impairment. And essentially, you can have impairments that may or may not affect the student's ability to what they call access the curriculum, or which would be learning, communication, social, emotional. There are all these different things. The ADA, or 504, of course, Section 504 of the Rehab, a lot of us are very familiar with that requires schools to accommodate, right? But
Okay,
they
so the
have to
504,
accommodate.
I didn't even know this. The 504, and this might be a little bit lawyery, but lawyers hopefully are listening and they need to know this too. So, and parents, because your lawyers aren't doing it, you need to know. So, 504 plans come, is it section 504 of the ADA? Huh.
Of the Rehab Act, yes. It's the
Yeah. Okay.
same 504 that we hear about all the time. Now, here's the main difference between a 504 plan and the IEP, ARD, but the plans that you get under the IDEA. 504 says we just have to provide the accommodation. There is no related service connected to that. It is merely the accommodation. So what would this look like? This would say, okay, X student gets to get time and a half when they take the test. That's an accommodation. Okay. It may say, okay, student gets to take their test in a separate room. So it doesn't interfere with their ability to pay attention. So that's what that will say. Your IEP, on the other hand, may say, okay, your student, if everyone else has, let's say, 100 questions, your student will get 50 questions, and it's still in their 100% would be based on a smaller or shorter amount of questions, right? In addition to that, if their challenges were in certain areas, they will say, okay, this student is either going to be taught inside of their classroom, let's say by a special education teacher, that's what they call push in, or they're going to be pulled out from their regular classroom and then they're going to go to a different classroom with a small group.
Is that called, what's that called?
Pull out. The key is they have to log all of that. They have to log the push in, they have to log the push out, and they have to track progress of the student. All of that is under IDEA. Section 504 just says we give little Johnny the opportunity and they have to take it and do their best. Now, for some kids, that's okay. That's all that they need. They just need a separate environment. They just need that accommodation. But for some kids, they really need that tracking. They need to know, like, they need that support. And so the IDEA allows for services, support, accommodations, a lot, sometimes even parent training, depending on what
Mhm.
type of accommodation or what type of services the student has. And they are legally responsible for implementing this. Now, in terms of recovery, and this may be a little bit beyond the conversation, of course, 504 ADA, you have comp damages, you have all of those things. IDEA, you do not have that. We have to look at whether or not these actions were a manifestation of this child's disability.
Mhm.
The other part, to your point, even in undiagnosed situations, if this child had had some, let's say, not as severe outbursts for the last throughout the school year, now it's the end of the school year, now they're destroying property. At what point prior to that should the district have said, we need an evaluation of little Johnny?
Mhm.
That's their responsibility, even if parents don't ask for it. So there's a lot of places that this can go, but I know that in the context of what we're saying is that parent education is so important. Just so you know, it is so important so that if you're in a custody situation, we would hope I know this doesn't happen all the time, Krista, but we would hope that parents can come together to navigate the situation with the child, because that's in real time. Little Johnny doesn't have time for you to go to mediation, for you to, after that, after go to mediation, figure out what we're going to do. Like, by then it's over, it's done. The school does not have to wait. The school is not subject to your parenting plan and custody arrangement in terms of what the school has to do from a processing standpoint. They have to follow it based on authorities and things of that nature, but the school is not going to stop a disciplinary process just because you now have to go to mediation to decide which parent can make the decision.